When we get to the end of the presentation, there'll be a resource page, including contact information for my office. In the meantime, for those of you who are in the room and watching online, there's programs that we sponsor at the county that might be available to you, that might be of value to you. We have county veterans assistance programs. We have a veteran service center in Tacoma at our building at 3602 Pacific Avenue, where we help veterans and families of veterans find if they're fully benefited, do claims under the PACT legislation. We also have a veterans housing program. So consider availing yourself of that by calling us or going on our website. The website is pierceadrc.org, and that will be shown on the final page of the presentation today. I'm also going to talk a little bit about the Dementia Legal Planning Project. This is a state-funded program to help put together some of the documents we're going to talk about today for free. So if you call them, you'll be able to get in touch with a legal person in your area to help you do powers of attorney for financial and healthcare and living wills. That phone number is at the end of the presentation as well. For those of you in the room, we have a flyer about that. For those of you dealing with any information related to dementia, a family member might have Alzheimer's disease or another dementia, we do have our Alzheimer's conference coming up in Parkland at the end of September, September 20th. It's an all-day free event at Rainier View Christian Church. It's all about dementia, dementia care. There'll be one aspect of legal planning that we'll talk about as well. We'll provide breakfast to you, also provide a free lunch. So I've got information on that for those of you who are in the room. Otherwise, call us. We'll probably start registration for free registration next week sometime. You can always go on our website and find information on that. And then for those of you out in this East Pierce County area, we'll do our Fall Prevention Awareness Day event on Monday, September 22nd. We're going to be at the Melcorum Family YMCA. That's the YMCA up on South Hill. And that'll be from 10 a.m. to noon on Monday, September 22nd. That's actually Fall Prevention Awareness Day, and that's the day we're having our event. So I've got the flyers on that. Again, you can go on our website and find out more information on that. And then finally, if you're in any kind of a caregiving situation and you're looking for support, Multi-Care, Good Sam Behavioral Health in Puyallup also has a support group that happens every first Wednesday of each month from 1 to 3 at their building at 325 East Pioneer Avenue. And I have the flyers on that as well. So for those of you in the room, feel free to browse the table when we're leaving. For those of you online, go on the website. You can find information about all these different programs and many more at pierceadrc.org. Okay, so let's get started on the presentation. Next slide, please, Jim. All right, I always like to give a disclaimer when I do this presentation that the information I'm providing is not intended to serve as an exhaustive list of legal documents. There's a lot of different variations. There's family trust. There's other things you might put together in addition to what I talk about today. And we always say that you need to do this planning with your family and trusted individuals around you, with doctors, attorneys, things like that, your minister, whoever the case might be, and family caregivers as well. All this should be reviewed in consultation, ideally with an elder law attorney. It's not necessary. The documents that we're going to show today are freely available to you online at washingtonlawhelp.org. You could print them out and complete them yourselves with the notary. But if there's something more complicated than that, there's also legal resources. We'll talk about Dementia Legal Planning Project, and the Tacoma Pierce County Bar Association also has a senior panel where they can put the documents together for you at a reduced rate. All right, next. And by the way, if there's questions that come up, I'll pause every couple of slides to get the questions. Okay, so the topics we'll cover today, and we'll probably finish around 11:15, I'm guessing. Why the planning for decision making is important for everyone. And it really is. In the work I do, we work with senior and disabled adults. It's not unusual. We'll have a 25-year-old gentleman who's on full care and is on one of our caregiver programs because they've had an illness or an injury at a young age. So it really can happen in any situation. I can think of my uncle, for example. He went in for knee surgery, and we had all the documents in place, simply thinking, okay, he's going to be unconscious for a while during knee surgery. No sooner had I got him home after knee surgery than the doctor called and said he needs to return. His kidneys are failing. It looks like he has leukemia. And so it went from a successful knee surgery to almost an end-of-life situation for treatment of leukemia, where he had to be unconscious for a full week. And thank goodness I had all the documents in place because I did have to make decisions about blood transfusions, kidney protective treatments, all kinds of things we had to do. We'll talk about the specific legal documents, ideally, that you'll want to use that are specific to the state of Washington. Now, they're all going to have the same names nationwide, but the language can be a little bit different state by state. So what we're talking about today are the documents that are approved and the language for the state of Washington. We'll cover financial and healthcare, durable power of attorney documents. Those are two of the primary documents you're going to want to have. We'll talk a little bit about what protective payee documents are for Social Security specifically, and why those are necessary in some cases. We'll talk about living wills, also known as advanced directives for healthcare, which are basically the script you provide to that person that you're designating to be your decision maker. We'll talk about how all of that differs from guardianship filings, which is a completely different thing. The things we're going to talk about on the power of attorney and living will side are voluntary, where you're discussing those with the person you're designating. Guardianship is where someone else is saying, you're not capable anymore and you're not cooperating, and we're going to go to court to determine that you're no longer capable of being your own decision maker. Very different process, but we'll touch on that. We'll jump to a little bit like number 7 to POLST forms, portable orders for life-sustaining treatment, also known as the DNR, do not resuscitate form. And Jen and I will kind of team up on that one, especially because she's more versed in that and how that works than I am. We'll talk a little bit about how all this is important and doubles when you're working in a hospice or palliative care situation, and we'll describe that a little bit. And by the way, later in the series, the series session 6 in November 18th, we'll be talking a whole session about hospice care and palliative care as well. Talk a little bit about necessity of having a last will and testament in place, and then we'll finish up, wrapping up, showing that resource page and some of the resources you can tap for legal assistance when needed. Okay, so why is it important? Why is planning for decision making important to everyone? Well, we all know the older adult population in the United States is growing, and it's actually growing rapidly. And that's really a trend that's happening, at least in the Western world, across Europe, Asia, all these different places. Fastest growing group of people in the United States right now are those 80 years of age or older, right? And I think we've all probably met people that are in their 80s that are functional, in their 90s that are functional. Anyone met anyone over 100 that's still functional? You have, how old?
Oh, I haven't.
She has no.
She is going to be 102.
Wow.
And she is just on top of things. You know,
Wonderful.
just her mind is like sharp as a tack.
Is she still living on her own?
No, she just lives over, I can't remember, Cedar
Ridge.
Yes.
Okay,
And
wonderful.
I've met her a few times, and I'm just amazed, you know, how we converse.
Yeah,
you know.
yeah.
I think she's smarter than me, you know?
Yeah, it's not unusual to have an extended period of retirement. My wife showed me a photo the other day. I think it was her 4th grade teacher or her elementary school librarian at a table blowing out candles, and on the birthday cake it said 106. Wow. She was turning 106 years old and still lives on her own with a lot of family help, but still living on her own. So not unusual, we see these extended periods of retirement, extended periods where a person's an older adult, out of the workforce, and still living a very long time. And that really falls to where the planning needs to happen with family members, because a sudden illness or injury could strike younger. We've all known people that have died very young, right? You know, in their 40s or 50s or 60s of sudden illness or injury. But we've also seen those people who live long periods of time. And sometimes you can live a long time and need a decision maker for a long time as well. So that's why we talk about it. Dual income households are more and more common. When I grew up, my dad had a landscaping business. My mom was kind of the household manager and did some bookkeeping for him, but she never worked full time. He did. My wife and I, from the time we were married, we were both working full time, right? And so it became very difficult when her parents started to decline. We took care of them and did all the decision making, and then my parents were a little behind them in terms of their decline, and then we had to do decision making, and somewhere in there my uncle was there as well, and we had to do decision making for him. So some of you may have already found yourself in that situation or are planning, if you happen to get into that situation yourselves, and how family members can help be decision makers for you. And that's why it's important, because with fewer children, more people working, people spread out more, you got to start thinking about who you're going to designate to be that person to make those decisions for you. And like my uncle that I mentioned, it could come as quite a shock. You know, I wasn't planning to be an end-of-life decision maker for him. You know, he went in for that knee surgery, everything went fine, but then boom, he's unconscious. Boom, I'm handing over documents and things. The encouraging thing for me during that process was that we had already given them the power of attorney form for healthcare. We had already given them the living will. He had already done the POLST form. So there was no question once we handed those documents over, even though his situation dramatically changed for the worse, there was no question like, well, how do we know these are legitimate documents? That didn't come up at all. It was simply knowing, oh, you've got the documents, great. So during this week when he's unconscious, we're going to be calling you about blood transfusions, about kidney protective medications, about different treatments we might need to try. So there was no question the documents were legit. Call me. I was on the phone constantly with them. So my experience with my in-laws, with my uncle, my parents are, if you have these documents in place, the healthcare providers are going to be very happy that you got them done ahead of time. Because if without the documents, then there's a hierarchy of decision making. It usually goes husband default to wife, wife default to husband, and then there's a family hierarchy after that. The problem comes up when there's some other family member that jumps in and says, no, wait a minute. I had this long discussion with mom and she said this, that, and promised me this, that, you know, then it becomes very problematic. So you want to have something documented in writing, notarized, that you prepared, that show your wishes when that decision maker has to take over. Okay, any questions on that so far?
The only thing I'll just add to that is sometimes, and if you said this, I apologize, I'm
No worries,
multitasking, but sometimes it'll be that with spouses, they'll make each other their decision maker, but not necessarily a secondary. And then when the spouse dies, that no longer is applicable. And so, you know, the person may think I've got legal documents done, but in fact, they don't anymore because the person that was their decision maker is no longer living to do that. So it's always good to have a secondary just in case, or to think of updating those documents on a regular basis. Absolutely, keep them fresh, especially if there's a change in someone's situation in terms of a new wife or husband passes away, someone's newly married. This just happened with a family member of mine. His wife of 30 years passed away, remarried. So everything that's out there that has that widowed wife's name on it needs to be changed. Because things like bank accounts, if you have shared bank accounts, they go outside of the probate process. And so if you had a first wife or husband, and his name was on that bank account, and then you decide to divorce that person, marry someone else, that information still lives on attached to that bank account. So I'm not a financial professional, but these documents are going to help you avoid a lot of those problems. But still, you have to go to do those financial reviews as well when you have a significant change of circumstance. And I, as a professional, cannot act as your decision maker. I've been asked to do so multiple times over my career. I'm sure Jen has too. Her team cannot be decision makers for you. The care facility coordinator where you're living cannot be the decision maker for you. The doctor at the hospital cannot be the decision maker for you. So that's why we have to have these documents in place. So there's something written down that says, yes, at the time I was of sound mind, I established this person, this family member, friend, whoever, as the decision maker for healthcare, maybe someone different for financial, and I have the living will telling them in an end of life situation what I want that to look like and what treatments I want or do not want. Okay, any questions on that? Clear? Okay, right, next. Okay, so more on why the planning is important. Illnesses or injuries causing loss of work or lifelong disability can happen at any age. And for those of you who do work in the field or visited a care facility or nursing home, you're going to see a lot of young people there too in very difficult situations because car accidents happen, traumatic falls happen, heart attacks, strokes can really happen even at a very young age, and we know that. Especially in husband and wife care cohorts. So we have a program called the Family Caregiver Support Program.
And that's one that you might walk away from today thinking about for your own situation or a friend or family member. And it's mostly husbands taking care of wives or wives taking care of husbands, one's healthier than the other. We have at least a couple of hundred couples on that program. It's designed to give relief to that spouse who's the primary caregiver for the other spouse. And so we have an agency caregiver come in 24 hours a month to give that person some relief. So that person can go to church, go to their own doctor's appointments, whatever the case might be. In those family cohorts, why do we want to put that help in there? Because anywhere from 30 to 70% of the time, depending upon what study you read, the husband, wife, or partner who is the caregiver dies before the person they're taking care of. Okay, and if any of you in the room or listening online have been in those caregiver situations, this statistic's probably not that surprising to you, because caregiving of someone who's seriously physically incapacitated or suffering from a dementia or a stroke or traumatic brain injury can be quite exhausting. And so what happens is people in those situations start to isolate because they're so focused on care of that loved one that they stop eating properly, they don't sleep well, they don't take their own medications, especially if they don't get to doctor's offices for doctor's treatment for themselves, and their health starts to decline as well. So a reminder, we do have programs here in Pierce County to help folks in those situations. So if you know someone in that situation and they're starting to isolate, I remember I saw one gentleman who came to our office in need of help. His wife had had dementia for a few years, and as the years progressed, she was getting worse and worse to the point where she started to wander. So when I went to see him after he contacted our office, all the windows were boarded up, the door was nailed shut. He had one door that was available to come and go at the house. And he would drag a heavy set of dresser drawers. He would drag that with a rope he had under the door. So when he left the house, he would drag it and pull it tight against the door, because that was the only exit point in the house. And he was so fearful of her wandering that was how he was handling that situation. And you can imagine how dangerous that is, right? He's basically locked up his house like a fortress to keep his wife inside out of the love he felt for her and the concern he had for her wandering. But that could be life-threatening, obviously. So this is a gentleman that we got care into that home. So each week, someone from an agency would be there to redirect her, to have lunch with her, to take her, help her shower, whatever, so he could safely leave the home. That's a very extreme example, but we see examples like that over and over again, where a person's just not getting any relief or any help that they need. So please let us know if you have anyone, if you're in that situation, or you know anyone that is, okay? Next, okay. So let's jump into the actual legal documents that you should know about for decision-making. Again, these are specific to the state of Washington. So any state you visit, if you're living part-time in Arizona or Florida, you're gonna see power of attorney forms. You're going to see them for healthcare, financial. You're going to see living will or advanced directives. You're going to see last will and testaments. Those are managed state by state. So each state has its own revised codes and Washington administrative codes that govern those documents. So the ones we'll talk about today are specific to the state of Washington. So there's things I hear about from other states where they'll say things like, well, you need multiple witnesses for a power of attorney form, or if I have one doctor sign the power of attorney form, then that gives me power over the person. It's like, doctors really aren't involved in the process here in the state of Washington, okay? People put a lot of power on doctors in the state of Washington that actually doesn't exist when it comes to decision making, okay? You might want to involve attorney, you don't have to. So an attorney doesn't have to review the documents and prepare them for you, nor do you have to get them approved by any court if we're talking just about power of attorney and living wills and last will and testament, okay? Remember that if you move to another state though, you're gonna wanna have copies of these documents updated with that state's own language on the documents, okay? So I imagine, I'm not sure, I imagine when I'm telling you there's similar presentations for other states. Now, I've never heard from anyone that if they had a state of Washington document and they briefly traveled to California, they became ill or injured, that the treating provider there contacting the son or daughter here ever objected to the fact that it was a state of Washington document and not a California document, right? But if you're consistently staying in that other state, if you're a snowbird person or you routinely are visiting family extended period of times, I recommend that at that location where you are extended period of times at other states, that you have the documents set up for those states as well. That way, if there's long-term care things that are happening there, then the documents are already existing in that other state, because these documents need to be set up before the need arises, okay? I couldn't have set up these documents after my uncle was unconscious, right? So I set them up with him before he originally went to the hospital for the knee surgery. So you have to set them up where you're well aware, capable, and healthy enough to understand what you're doing with the documents. And when the notary is talking to you, the notary may ask you questions like, do you understand the documents? Do you understand what powers it gives, what you're signing? Who are you? Asking all these questions. It's not unusual that families will call us at our office on a Monday and say, oh my gosh, mom had a stroke on Saturday, she's unconscious. We don't have power of attorney forms, what do we do? We're like, well, it's too late. Hopefully she'll recover and can sign the document, but you can't impose it on someone who's unconscious. These are voluntary, willful documents with the understanding that the person in question has full knowledge of what's happening on the document, okay? Next. Okay, so let's start durable powers of attorney documents for financial and health care. So this document designates another person or persons, like Jen was saying. You could have primaries and secondaries on there, or you could have two people listed as the co-decision makers, to be your acting agent to make decisions for you when you're no longer able to do so. So it's voluntary, it's understood by you, no one's imposing it on you, it's you willfully saying, okay, son, let's go ahead and get this document together. I'm listing you as the power of attorney for financial or healthcare or both, okay? These documents should be completed in consultation with the person you're talking about that's gonna be on the document, okay? It always amazes me when people tell me, well, I'm gonna do the power of attorney, I'm gonna designate my son, daughter, whoever the case might be, but I'm not gonna tell them because I really don't trust them. It's like, well, there's a lot of problems with that statement, okay? So first of all, whoever's named on there needs a copy of the document, okay? It doesn't just float up in the sky so someone can grab it when they need it. Number two, that person you're putting on the document should be someone you trust, and trust enough to sit down and discuss with them about being on the document, okay? Because that person might not want to be your decision maker, right? They might not want to be your executor for your last will and testament either. And again, when you go in for care, the doctors are going to ask, who's your power of attorney? And then they're going to want to contact that person, okay? Because then if you go unconscious or you're ill or injured, they want to know who's going to be making decisions for you. So these are discussions that have to be done ahead of any illness or injury, with all parties involved fully knowledgeable of what the tasks at hand are, okay? This next point is a little bit of a sticking point. This is my own view. I always say when I give these talks that powers of attorney documents, especially for healthcare, should be written to be effective immediately, okay? So this means like Mrs. Jones, you come to me and say, Matt, I want to set up these power of attorney forms. I always tell them, okay, here's the forms, you can find them online, talk to your attorney, but make sure that now that you're healthy, you're not ill or injured right now, but you're planning for the future, that that document be effective immediately. That means you're telling on the form legally that your son John is going to be your healthcare power of attorney decision maker. And then as long as you're ill or injured, John's happy. He doesn't want to take over things if he doesn't need to. He gets a copy, you take a copy, you put it in your cabinet at home, he puts it in his cabinet at home. You have a family attorney, you give them a copy, you give your doctor's office a copy. That way, if tomorrow, God forbid, you have a stroke or a heart attack, it's all done. Or if tomorrow you're fine, there's no need for it, but it's already completed, okay? In the state of Washington, you can have a power of attorney form that says it's effective at incapacity. In my experience, doctors do not want to be the one who signs off on you being incapacitated, because that means they're diving into a family situation where son John, who's listed, says, okay, I'm ready to take over. Sister Mary says, mom's just fine, leave her alone. Don't you dare make decisions for her, right? And the doctors do not want to get in the middle of that. So
And
trying
some
to
of those-
establish incapacity can be very difficult. Yeah.
And some of those forms actually require 2 doctors to declare incapacity, which is even harder to
Even
obtain.
harder. We were dealing with this just yesterday. We have a client that wanted to get on a paratransit Medicaid transportation service. That requires that her primary care doctor send a letter, there's a form they fill out, to paratransit to say, yes, this person's incapable of riding the bus and can't drive, okay? This person has not seen a doctor in years, and the doctor they assigned to her to see has left practice. And so she's in complete limbo land, just to get this bus service set up. And I know my wife has had multiple primary care doctors come and go at Kaiser. Right now, it's very difficult not only to see a doctor, but to see a doctor you've even met before. And you can be damn sure they're not gonna sign to say you're incapacitated. Even if they meet you, they're gonna say, she looked fine to me the 10 seconds I talked to her in the office, right? They don't know. So again, this is part of this talk is kind of taking away your view of what the doctor's abilities and desires are in terms of your personal situation, okay? They're there to treat you for healthcare, illnesses, and injuries. They really don't like to dive into these other things that they can avoid. Anything more, Jen?
Just, it's important to realize if this take-home message hasn't been clear, there's not one boilerplate document for power of attorney in the state of Washington. It will depend on what lawyer you go to and what form they use. My dad's lawyer, when my stepmom died, he did redo his documents to make me his power of attorney. It initially was that it was only when he was declared to be incapacitated. We had to sort of, force the lawyer to rewrite that as a form that made it effective immediately, which I pushed just based on my years of experience, in running 911 calls and dealing with that. She finally did agree to it and used a different template that made his power of attorney effective immediately for me. But you can't
Exactly, yeah.
assume, and you've got to read through the language of the power of attorney when you get that done to understand how it's written.
Exactly, and the husband and wife situation is common. It was the same with my parents, and my dad had no interest in being the decision maker for my mom, just because his hearing was bad. He was originally born in Italy, so English was a second language for him. And so when she started to decline before him, we did that same thing. We had to meet with the attorney and kind of swap everything out. So mom was assigned to me to be power of attorney, same with dad. And so one person's kind of coordinate. Different families can do it differently, but it becomes problematic as people get older for that husband and wife situation. Now, you could certainly put a secondary in there to say if husband and wife's not capable, but not capable can be kind of a nebulous kind of concept too. So just make sure the language is understood. Ideally, it's someone in the next generation, if you have someone in the family you trust who takes on that role. And then typically for the power of attorney forms, you're going to need to have them notarized or 2 disinterested witnesses signed. So in my situation with my uncle, for example, the attorney we were working with had witnesses that were in her office, basically her office staff. So when we went in, they had witnesses, but typically attorneys' offices have someone on staff that's a notary. There's mobile notary services now you can hire. They'll come out to where you are for like $75 and pay them to notarize documents. So that process isn't as arduous as it used to be because there's so many options available for that kind of thing. Any questions? Yes.
What does disinterested mean, witnesses?
So it has to be someone that's not related to you or involved with you that's
Okay.
involved. So generally, the notary rules are similar. So like my wife was a notary because she worked in my brother-in-law's law office. But under the statute, she couldn't notarize documents within the family.
Okay.
So we had to find someone outside the family, disinterested, not related and involved that did that. So great question there. Disinterested witness is someone, they call it an arm's length relationship. You're kind of this far away from them. So, and they might know you in a professional capacity, but they're not directly involved with the decision-making consequences of what they're verifying. So good question. Thanks. Okay, Protective payee documents for Social Security, since we're kind of focusing on healthcare and financial. Social Security, most of our seniors have Social Security income of some kind. So, like we were saying, power of attorney forms are specific state by state, okay? Social Security is a federal program. So I was in for a shock when I called Social Security with my mom next to me, and she was suffering from dementia, and talked to them, and I said, okay, I'm here with my mom. I just want to find out where I send my power of attorney form so I can communicate with you at Social Security. And they immediately said, we do not recognize power of attorney forms for communication with us. Either she talks to us or you become protective payee for her. And a protective payee is basically your request of Social Security, and you can find the documents online, where you're saying that you're managing that income for your mom or whatever the case might be. Typically, a doctor has to verify that, yes, it's a good thing that someone else is managing it. So again, you get doctors involved. We worked around that, our strategy, by just having my name on the bank account into which the Social Security went. So each month, Social Security would go in. I had access to the bank account. I had the financial power of attorney, and we went in and specifically took down that process of being on the bank account. So I was able to access that money to pay for her needs. There was no plan that they were going to move from where they lived, so we continued to keep the address for the bank account, and that was the address of record for Social Security. So at the end of the year statement, I would use that for different things I was doing for her. I would get her new award letter. So that was the easy workaround for us to do that. You can also set up a socialsecurity.gov account as power of attorney and kind of pull documents on there if you need it, make any changes you might need. They're getting a little more restrictive on identity on that, so I don't know how easy that still is, but for us, the workaround was the bank account. Now, I've had family members who become payees for Social Security recipients. There's also professional offices that you can assign to be a payee for someone on Social Security, and they charge a minimal amount, I think $50 a month or something to do that. But in most cases, we didn't find that to be a problem, nor did my wife with her in-laws find that to be a problem, because we were attached to the bank account into which the payment went. So any questions on that? I always bring it up because it always comes a bit of a shock when we're routinely talking to family members and they'll ask us, well, I can send the power of attorney to Social Security, right? Like, well, you can, but they're not going to honor it because that's state, not federal. So, okay, next. Okay, advanced directive for healthcare or living will. So backing up a little bit, the power of attorney forms, you can have it combined where it says you're granting both healthcare and financial decision-making power on the same document. Like Jen said, different attorneys' offices might use different documents. If you go on WashingtonLawHelp.org, they're typically existing in two different documents. So you have a healthcare decision-making document and a financial. Healthcare governs anything regarding treatments of illnesses or injuries you might have. The financial one is to manage bank accounts and investment accounts and things like that, to be the financial decision maker, okay? But you can combine the two in one document. Again, that's not a problem to do that either. It's a little more convenient to do that. But then as far as advanced directives goes, or also known as a living will, this is where you're basically providing a script to follow for that decision maker you've designated to be your healthcare power of attorney. And that's to follow your end of life wishes, like medical treatments you may or not want to have if you're terminally ill or permanently unconscious and unable to make decisions. So let me give the example of my mom. She had a series of falls with her dementia at home, became more and more ill. And so finally we had to put her into the hospital after the last fall and put her into care. So in that skilled nursing facility, we had already had all the documents set up years before. She had a steady decline to the point where the last couple of weeks, she was completely unconscious. She could actually open her eyes, but she couldn't communicate at all. So we had hospice care come in to kind of evaluate, is she in pain? Because the skilled nursing facility is like, you know, we can treat her with some pain medications. If she's in pain, there was no indication she was really even in any pain. Her body was just shutting down. But we had them work with us anyway. So then the question became, like on the second paragraph here, artificial hydration, artificial nutrition, assessing her for those things. And again, they kind of assessed that early on. They're like, okay, yeah, you know, if she needs to be hydrated, we can hydrate her, we can do these other things. But then very late in life, probably like the last week or two, they were like, hospice care was telling us, really doesn't need hydration any longer, really doesn't need nutrition because her body is shutting down. It can't, the body in that situation is no longer able to absorb nutrition or hydration. So these were things we had already written into the living will. We had said all in that end of life situation, as assessed by hospice, it doesn't have to be assessed by them, a doctor can assess what the end of life situation is. Do you want these things to be imposed upon you? And my mom said, no, I just want to die comfortably, peacefully, painlessly. So I want pain medication in that end of life situation. So that's what the living will is providing for that decision maker. It's your advance notice, advance directive to them on what that end of life development is going to look like. And there's a longer version of what you might find online. Again, Washington Law Help has the living wills. There's one called the 5 Wishes document, where you can list what Bible, chapters you want read to you, what music you want playing. Is there a certain sense of candles you want burning in your room? Is there anyone that you would like to have tell stories to you? Is there a specific favorite blanket you would want to have on you? So it could be like, what's the whole setting gonna look like that you can incorporate in the living will? And that's available at 5wishes.org. Jen, you want to comment?
Just to point out that Washington Law Help also has other forms of advanced directives. So my dad has Alzheimer's, he's still pretty cognitively capable, but we went through, there's a specific advanced directive called mental health dementia advanced directive, and it goes through some very specific conditions that might pertain to somebody with dementia, like aggressive behaviors and driving and things like that. So we went through and had a very deep, meaningful conversation about what things could happen in the future, and he filled out that advanced directive, which is in addition to his healthcare advanced directive. There's also one called a voluntary stopping of eating and drinking, or VSED, that can be filled out separately. So it's a good website to look through and just know that there's different types of specific advanced directives available.
Absolutely. Any questions on advanced directives and how they work? It really is nice to have it in place. I know in our own family, there was some dispute among family members of what it meant to have artificial nutrition, artificial hydration, what it meant in terms of the comfort level of my mom. Having the hospice care involved and talking to everyone about that was really useful, because there's an assumption that lacking those things, the person's going to quote unquote starve to death or dry out. And that was kind of the disputes that were happening in my family. And you get to a point, and Jen knows more than I do on end of life stuff, you get to a point where the body is no longer able to absorb those life-sustaining things. So we think we're walking around fine, yeah, I'm hungry, I better eat, I'm thirsty, I better drink. That end of life situation is very different. So as the nurse explained to us, you basically would be like trying to push a tube against a wall and make something happen, and nothing's gonna absorb. But the dispute you might run into there too, and this is why it's useful to have these documents done ahead of place and talking to the relevant people, is that my mom was in a skilled nursing facility, so their view was, well, we gotta keep her alive, that's what they do, they're a medical facility. So having hospice care overlay there and make sure all the orders were coming through hospice care also helped some of those in-facility disputes that can arise as well. Next. Okay, so we talked about these documents, healthcare and financial powers of attorney, living wills, as voluntary documents. So the whole discussion is about you need to be in talks with the people around you as to who's going to serve in that role and what the script will be for them to follow in a cooperative way, okay? While you're healthy enough to have the discussions early on, not later, okay? And my view, again, is different than what some other attorneys' view might be. My view is everybody involved with the document should know, and people otherwise in the family should know as well. And one of the other talks I always say, proximity does not indicate capability, okay? That super close son or daughter that you have, that's your best buddy, might not be the best person to be your decision maker, because these decision makings are pretty difficult. They can be very gut wrenching at times, and that close by person may be the best person, or they might not be the best person. And we get questions from families like that all the time. Well, who do you think will be best among my kids? I'm like, I don't know. I was the youngest, I was the professional. So I ended up doing it. Many family traditions is that the oldest always is the one most involved in decision making. That's your own family dynamic and kind of understanding that. That's why the discussions need to happen sooner rather than later, okay? So if all of that fails, if you're recalcitrant, you don't want to have the discussion, your family's at odds with you, whatever the case might be, then there is a process where a concerned family member or even a friend, we've even had neighbors at times, file what's known as a guardianship. So a guardian is a person appointed by the court to be your decision maker. Okay, so this is someone you probably might not even know. It could be a family member. In many cases, when the person has a substantial estate from which to draw, it could be an attorney's office that has a guardianship activity within it, okay? If you have the forms that we're talking about, that really forgoes the need for guardianship. So in my experience in the work I've done at the county, typically a guardianship happens when it's a person living alone, doesn't have any close by relatives or no one living close by, might have been estranged from them. And then either the state of Washington through Adult Protective Services assesses the need for guardianship, or again, it can be family too. We've had families where the person had a substantial estate, but they're just not cooperating, not getting the health care they need. They're falling, they're lighting their kitchen on fire, they're driving and getting in accidents. And so that family can petition the court to have a guardian assigned to that person, okay? It's an adversarial process, meaning that that person is telling you, you're not capable of being decision maker anymore. That's my belief. We're gonna let the court decide. I'm on one side of that argument. You're on the other side. The judge is in the middle. You're gonna get served with summonses and requests for documentation and all these things. You can respond, but it's adversarial, okay? It's basically no one cooperating in the process to get these documents for decision making in place. And so in that case, then the guardianship, if awarded, the judge would decide who can act as guardian. And again, if there's a capable family member, it could even be the petitioner. They might be designed as guardian. It might be a professional office. We've seen both things. We've had actually a neighbor once be assigned as guardian because he's the one that started the process. So it can take on a variety of different forms. But again, it is adversarial. And so again, this is something unique to Washington as far as I know in terms of the process. Now, other states probably have something similar. But in Washington, it's become more adversarial over time because Washington leans very much in the direction of older adults having autonomy, making their own choices. It's very difficult to impose a guardianship on an older adult. So it's very different than custodial care for children, okay? Custodial care for children acts very differently than it happens with adults, okay? Any questions on guardianship? It's a very difficult process. Do you have anything on that? Yeah. Okay, great. All right, so another document you'll typically want to have in place for planning is a portable order for life-sustaining treatment, also known as a POLST form, sometimes known as a do not resuscitate form. So typically, if you're seriously ill or in very poor health, a doctor might ask you for this. Now, in my experience, they're going to ask you for this no matter what's happening in your health care, okay? Because they want to have this in place, again, because we know that sudden illnesses and injuries happen suddenly. So they prefer to have this document in place than not, okay? But for sure, if you're going in for anything, going to an emergency room visit, you're going to a scheduled surgery, they're going to ask you, who's your healthcare power of attorney, where's the document, and do you have a POLST form in place, okay? So this is basically you also designating what your emergency care needs would look like and what you want to have happen. So we typically think about it in terms of having it in case something happens, and then having it because you're already very ill or injured, okay? And so it's kind of a distinction going both directions. Regardless, in most cases, when you talk with your doctor about it, he's going to ask you questions as if, what do you know about your situation now? What would you like to have happen? And in a terminal condition, what would you want to have happen? It's specifically related to cardiopulmonary resuscitation, okay? So I'm gonna let Jen kind of chime in and let her experience on this because she's firsthand a lot of that, so.
So again, the POLST is really for when there is a life-threatening situation going on. So there are a couple of different parts to the POLST. Part one is basically very simple. CPR, yes or no. Somebody, their heart has stopped, they're not breathing, their body is naturally dying. Do they want us to put a tube down their throat to breathe for them, start an IV, give them medication to try and restart their heart, apply electricity to restart their heart? It's an intensive process. Do people want that, or do they want to simply be allowed to die naturally? Okay, that's part one. Part two is for if you still have a pulse and you're breathing, but you've got a life-threatening condition. How do you want that treated? Do you want full interventions? So again, we're going to do everything we can to save your life. Do you want to have, a family member on your behalf make some decisions? Maybe you want IV antibiotics, but not necessarily a tube down your throat to breathe for you. Or do you just simply want to be kept comfortable until your body dies naturally? It's not a conversation that physicians, nurse practitioners, PAs are always very good at having. We don't talk about death very well in this country. And so a lot of times things aren't explained in that capacity. And it generally tends to be instructions that are for us, for the first responders that are coming to your home when that life-threatening situation is happening. We always want to take that form with us to the hospital. The hospital is then going to tend to, they'll make decisions based on that form initially, and then they're going to kind of lean more towards those advanced directives that are a little bit more long-term. So hopefully that kind of helps explain the POLST. It's generally on a bright green form. We recommend people put it, on the back of the bedroom door or the refrigerator. That's where we tend to look for it. And again, copies of it should go with the loved one to the hospital if transport's happening.
Right, thank you. Yeah, and it is a form that does happen in consultation with your doctor. Okay, the doctor actually keeps custody of these forms. And then when you have the discussion with them, they'll keep a copy of the file. Sometimes they'll scan it in for a shared record that goes with multi-care Franciscan, but you'll get a copy of it to bring home with you, or the original to take home probably. And then that helps govern these emergency situations like we were talking about. And again, the emergency situations can look different depending upon what stage of illness or injury you might be in, right? So if you're going in for knee surgery, like my uncle did, and if he had gone into cardiac arrest, I mean, yeah, you would want to have extraordinary measures to keep him alive. But in the last couple of days of his life, when his leukemia advanced and he had a colon blockage, he couldn't eat anything, vomiting, all of it, of course, then that situation changes. Then it's like, okay, no, he's dying. He's quickly dying. So if he goes into cardiac arrest, then no, we wouldn't want to do extraordinary measures to try to keep him alive in that immediate situation here. So I hope that distinction helps a little.
Someone online mentioned in the news recently, apparently Jay Leno filed to get guardianship over his wife who was suffering from dementia. Did he have to do that because they didn't have durable power of attorney and healthcare directives in place? I don't know about this situation, but I would guess that would be the case.
Yeah, that would be my guess, is that the guardianship was filed in lieu of having those documents set up, or in lieu of having them set up comprehensively enough to handle what was happening. And like Jen said, you can jump from just a standard healthcare power of attorney to a dementia-specific power of attorney form. So that might not have been completed properly or had not been put ready yet. And then dementia is a tricky one because it's a little insidious in terms of how it comes on a person. In the early stage, a person might kind of notice they're having some deficits here or there, but they might be adamantly saying, no, it's just senior moments and things like that. So then it gets a little murky as to how well that person is to actually sign the documents, okay? Again, we get this conversation a lot from family members. Mom's not cooperating, she's wandering, but I want her to sign a power of attorney form. Sounds like she's probably not able to sign under the state rules if she's that far gone. So that might have been the circumstance as well, that over time it developed, and then all of a sudden she's not able to sign legally because she's not understanding what the document looks like. So that might require guardianship too.
Yeah, I'll also bring up the situation with the different power of attorneys. I don't know this situation specifically, but I know when my mom, who now has advanced Alzheimer's and is in a facility, but when she was still living independently, we would try to have those conversations with her. And we knew that she had power of attorney set up, but we didn't have copies. We tried to have these conversations with her, and she really would refuse to talk about it. She wouldn't acknowledge, no, it's like Matt said, senior moments, I'm fine, there's nothing wrong with me. We thankfully were able to kind of, take over that control, get the power of attorneys, get her moved into a facility where she was safe. But let's say Jay Leno's wife had a power of attorney that was filled out that said that it only takes effect when she's declared incapacitated. And she's going into the doctor's office going, I'm fine, there's nothing wrong with me. And he's looking at her getting into car accidents because she can't drive, not taking her medications, doing things that are dangerous. He may have then said, well, the doctor's not willing to say she's not capable of making her own decisions. I'm seeing an unsafe situation. I can't beat the power of attorney even though that paperwork's in place because there's that capacity clause. So I'm going to go to court and seek guardianship, right? So that could have been the situation as well. And I'll use that as an example of why it's important to understand how that power of attorney paperwork is written.
Absolutely, yeah, great commentary on that. And then even thinking with my mom, having had the documents in place after her dementia continued to progress, if I were to have asked her, Mom, we need to take you to the doctor. Oh, I went to the doctor yesterday. It's like, no, you didn't, Mom. Okay, Mom, take your medications. I already took them. No, you didn't. So again, this is where kind of the family surrounding the person and being kind of a monitor for them. Because given her decision-making at that point, she would never have seen the doctor again, right? And she would have never taken her medications again. But as far as she knew, she'd seen them and they were taking them. So this is where it gets challenging because that's not the point where you think, oh, I need to get the power of attorney form. It needs to happen long before that process. And that's, again, I don't want to sound repetitive here, but that's why sometimes that close by family member who's always there doesn't necessarily see those changes that are happening. So sometimes it's the infrequent visitor who said, whoa, she's a lot different than she was a month or two ago. Something's changed here, right? So that's why I kind of emphasize knowing your own family dynamic and who's going to be best for the decision making for you is very important. So.
One more question came into the POLST. Are these decisions not included in the healthcare directive? They are separate forms.
Exactly.
And there may be an element of CPR or no in the healthcare directive, but again, those are kind of more used for once the person's in the hospital. That bright green POLST form is really the best thing to very clearly communicate to first responders or even facility staff if somebody's in a long-term care facility of what their wishes are, CPR yes or no, and what type of treatment course they want to take, full, limited, or not.
Yeah, so again, any more part of the package here in Washington, and I think it's even written into doctors' standards here, they're going to want to ask you about healthcare decision-making, living wills, and doing the POLST form. So this could happen long before you're going to be in some terminal situation where the POLST form is going to be specific to say in that spot, don't do the CPR, don't do the extraordinary measures. Versus the living will where you're looking down the road and saying, okay, what's that end of life time going to look like for me? What kind of music playing? Do I want artificial hydration, nutrition, things like that? This is again why when it heads to that terminal situation, that's why we do talk about hospice care, palliative care, because once you get into that terminal diagnosis where the cancer is clearly advancing or the congestive heart failure is clearly advancing to the point where the person's got a shorter time to live, that's why we want to make sure we have those documents in place. And that's when the POLST form is going to be more really a directive to say, okay, we now know this person's terminally ill and dying, and they had already said their living will ahead of time what they would want to look happen. And their concerns at that point were, can I pass away painlessly, comfortably? And so that's why the two documents are different, but they can kind of overlap and entwine with one another in a very end of the life situation. So. Okay, I mentioned hospice care a lot, so let's talk about it a little bit and why I think it's important. Hospice care is for those of you who are on Medicare. It's covered under original Medicare Part B. Even if you're enrolled in a Medicare Advantage plan. So if you have an Advantage plan like United Healthcare or Humana, you look through their benefit booklets, it's not going to say hospice care. Hospice care still lives with original Medicare, okay? Palliative care can be covered by B or Medicare Advantage. So let's look at hospice care first. That's an end-of-life medical care providing emotional and physical support for patients with terminal illness. It's reserved for those who've been said by a doctor to have a life expectancy of 6 months or less, okay? My mom was on hospice care, my dad was on hospice care, my mother-in-law, father-in-law. Mother-in-law went on and off hospice care for 3 years, okay? She had a variety of ailments and kept recovering from them to the point where she was no longer terminal. Then she'd go off hospice care, and then she'd go back on when she got sicker. So the idea of specific knowledge of your terminal condition, the doctor can look at ailments and say, yeah, this is going to ultimately end the life of this person. Can he actually set a date on it? Probably not in most cases. So I will say that hospice care, once we completely removed nutrition and hydration from my mom, they said, within 7 days, she will pass it. On that 7th day after they said that, she died. So it has to be very specific for things to be happening pretty quickly. But those terminal diagnoses can happen on and off. The trick with hospice care is once that diagnosis is made, and again, this is a discussion you're gonna have with family members, the doctor, your powers of attorney, all those things. The treatment you're having for that condition then ends. Okay, so if you have brain cancer, it's progressing, you've tried everything, and the oncologist says, well, we could try one more thing, and you say, no, I'm done, that's when you can go on hospice care. If you say, I want to keep going, then you might be on palliative care. Palliative care is focused on keeping you healthy in terms of comfortable and least impacted by the symptoms of the illness or treatment you're undergoing. So that person with that advancing brain cancer who wants to continue treatment might be on palliative care for proper pain management, managing nausea and side effects from chemotherapy, radiation, but they wouldn't be on hospice care because they're continuing treatment. So let me give you another example. I had another uncle who had stage 4 renal failure. He was on dialysis. My dad would take him. He was on palliative care because he also had a lot of pain, breakthrough pain that they were managing for him. His wife had already died, his grown daughter had already died, so at some point he just told my dad, I'm done, I don't want to do the dialysis anymore. So that basically gives you maybe a couple weeks left because your body will start building up toxins and you're gonna die. So at that point, it went from palliative care to comfort care, hospice care. The last couple of times I saw him, he was sleeping quietly, completely unconscious. So that's the difference there. He had a terminal condition, which was the stage 4 renal failure. He was being treated for it with dialysis. And then at some point he said, I'm done, I don't want to do it anymore. And then it became hospice care. Any comments on that, Jim?
No, that's a great example. And well, I guess the only other thing is I would say is, I've worked with individuals that have said, I'm not ready for hospice because hospice means I'm dying. Hospice means you are expected to die within 6 months because you have a terminal condition. But there are people that end up going on hospice and then doing very well. Maybe it's because all their medications are removed. Maybe it's because there's just a different, course of wellness that's going on. But there are people that actually do better, and now they're no longer expected to die within 6 months, and they
Yes.
come off of hospice
Yes,
and
absolutely.
continue on, maybe go back to palliative care or whatever. And so it doesn't necessarily mean, people think hospice is a death sentence. I've heard that term.
Yeah.
That's not necessarily the
No,
case.
no, not
It really just has to do with how we're treating, right? And what bucket of money it comes out of, really, from a
Yeah.
Medicare standpoint.
Absolutely, and they typically will provide some supportive services like a bath aid if you're living at home. Sometimes they'll have a minister or a chaplain involved to kind of help you with the spiritual aspects of being in that terminal condition. And I've heard different things from different family members of saying things like, well, my husband developed a urinary tract infection and they said they wouldn't treat it because he's on hospice care. I hear a lot of stories like that. So when you're considering hospice care for yourself or a family member, please have that discussion with your primary care doctor, and then whoever is going to be managing the hospice care. Typically a social worker is the first person you're going to meet to kind of talk about the parameters of the hospice care. Those are the questions you have to have asked ahead of time, because I hear a lot of things that don't square with my understanding and own experience with hospice care. So let me give you an example on that. My dad, in the last couple of days of his life, he developed a fever, okay? hospice said, okay, his fever is secondary to his imminent end of life, because Jen might verify I'm not telling this wrong, but generally blood flow and all support comes back to your torso to support your vital organs. That can raise your body temperature, which is why extremities get cold, and a person might say, I'm freezing, because all the focus of the body is going back to the torso. That produces the fever. So the care facility he was in said, well, we need to start him on an antibiotic because he's got a fever, right? That's standard treatment. Hospice care, who has the decision, once they're on hospice care, you call hospice care, not the doctor anymore, you call hospice care. They said, no, that's another stage in his end of life journey. So no, don't treat him with that. So that's very specific, but I've heard things different than that, where early on, the person's walking around well, even though they're terminally ill, develop a urinary tract infection and are told don't treat it. I don't know if that's accurate. What I'm describing, I know to be accurate. Other things I hear don't sound accurate to me. So that's why you want to have that conversation with doctors and with the hospice care provider.
Another misconception with hospice that we even face with our firefighters sometimes, because there is confusion out there, is that when somebody's on hospice, if they go to the hospital, they lose their hospice. That's not necessarily the case. If somebody's on hospice for cancer and they want to go to the hospital because of something related to the cancer, then they could have to temporarily revoke from hospice, because again, it has to do with that bucket of money in Medicare, what it's coming into. Medicare is not going to pay for a hospice at the same time as they're paying for in-hospital care, right? So they might just have to come out of hospice for a little bit, get whatever's happening on a short-term basis, treated in the hospital, come back to the home and go back on hospice.
Yes.
But if somebody's on hospice for cancer and they fall and they break their arm, we want to set the arm. We want to get pain medication on board. Whatever is going to be needed to take care of that arm in the time that they have left. They're not going to lose hospice for that, because Medicare will pay for a different condition in the hospital. So it can be kind of confusing, yes. But again, like it always, if somebody's on hospice, that decision should always happen with whoever the hospice point of contact is, whether it's nurse or social worker. They should be involved in making those decisions.
Yeah, that's a great example. I've heard families talk about that a lot. There's like a fear of abandonment, I think, when it comes to going on hospice care. Like, okay, they're just going to sit in bed and die. Nothing's good's going to happen. A lot of good things happen in hospice care. It's just a change in the treatment modality from active treatment for the terminal condition to more focus on comfort care. But Jen's right, you're not going to be very comfortable with a broken arm, right? So they will treat that because they want to keep you comfortable. So this is, again, some misconceptions you might hear from people who talk about hospice care and their concerns about it. So next. Okay, we'll talk briefly about last will and testament. Again, this is one you could set up without an attorney's involvement. Typically needs to be witnessed or notarized. This is basically you assigning, again, decision-making power to someone to manage your estate after you die. Okay, that could be your home, it could be investments, the belongings in your home, things like that. Typically, again, this needs to be set up long before you die, okay? Because again, we get calls from family members, there was no will, what do we do? Well, there's a probate process that the county has, that the state has, where you live, that basically will take all your information as a family member. If the person dies, what is known as intestate, without a will, like my sister died that way recently. And then you'll file all kinds of documents. It's expensive, it takes a while, the judge has to review everything. And then the judge will decide, okay, this heir gets this, that heir gets that. This person in the middle has to take care of all the final arrangements and things like that. So having a will basically avoids all that probate problem. You still have to file the will in court and have the court approve it, but it avoids all that decision-making after the fact because it's already spelled out in the document. So in that document, you want to say list of all your financial situations, real estate, whatever the case might be, personal belongings, where you want them to go, and assign someone as being your executor to take care of all that for you. At the time of death, power of attorney forms end with you. They die with you, okay? So again, family members will call us all the time and say, well, we don't have a will, but I was mom's power of attorney. That is completely meaningless in terms of settling your estate. Similarly, people will say, well, mom was ill, she became ill, she had a stroke. we don't have a power of attorney form, but I'm her executor, completely meaningless. The will is completely meaningless before you die, okay? Completely different things. You could have a person listed as power of attorney, different person listed as your executor. Again, depends on the family dynamic. My practice is always to say, get it all done early, update it periodically, make sure the assigned people have a document, make sure other involved professionals, doctors, attorneys have a copy. You keep a copy in a cabinet, we know where it is. You can record it at the county auditor's office if you want it to be accessible in a recorded document form. Apparently, there's also something down at the county superior court clerk's desk, I've heard, where you can actually have a will filed for you there. But again, everybody should be aware there's a will, there's power of attorney forms, everybody should know where their copy is. Everybody periodically, every year or so, should go back and say, okay, everybody knows where it is. Does anything need to be updated? Anything need to be changed? Because we're not the eyes in the sky and trying to find wills for people. And believe me, we get calls like that all the time. Well, we know we filed it, we don't know where it is. Well, then you gotta go look for it. My neighbor was that same situation. He had document after document going back decades. Took weeks for his brother to find the will amidst all these other hundreds and hundreds of documents he had. But he had it, he had filed it away. They knew he had it somewhere. Very difficult for the heirs to deal with that. So make sure everybody knows where it is. Now, I've heard other attorneys say, don't tell anyone where the will is. That's not helping, okay? Don't tell Susie, your daughter, that brother John is gonna be the executor, because there's gonna be a big fight. Well, there's gonna be a fight at some point. So get it early and often, get it taken care of. That's my view. Different attorneys might say other things about that, but that's my personal view on it. And we don't administer fights about estates either. We get calls like that all the time. I know my brother John's the executor, he's got the will, he's not showing it to me. I know he's taken everything. What do? You go talk to an attorney, because you're gonna have to sue your brother to get a summons to appear and show that will. No one else can take care of that for you. It's a family matter, it's not a criminal matter, it's a civil matter. So the police aren't gonna go knock on your brother John's door and say, give us that will. They're not gonna do that, okay? It's a civil matter. You're gonna fight it out amongst family members and spend a lot of money on attorneys to make that decision for you, okay?
Which is all the more reason to have those conversations, you know, with everybody.
Absolutely.
Up front before everybody's in this situation.
Absolutely. All right, next.
Okay.
Okay, and then just some health and safety tips for family caregivers. We always want family caregivers to have some basic first aid, some caregiving fundamentals classes. Always want to coach you about proper lifting techniques, proper bathing, showering techniques. There's a lot of tricks you can find out by learning proper caregiving techniques. You can call our office, you can go on pierceadrc.org. There's a lot of good information. There's a whole list of YouTube videos you can watch through an outfit called Trualta. We can give you information on that. It's free. You just set up an account. You can watch 2-minute long videos about caregiving. You can watch an hour-long video about caregiving. Plus, we always have classes, ongoing presentations about different aspects of family caregiving, things like that. We can help you with all that. Next. And we did list caregiver support groups there. Like I said, Multicare has one in downtown Puyallup that meets first Wednesday of the month.
See, Bonney Lake Senior Center has one.
Oh, great, good.
Sumner may.
Sumner's got one too. You're right, Sumner. Yeah, we've got a few right now. We've kind of got a wealth of caregiver support groups. So yeah, Sumner definitely doesn't have one as well. So, and then again, we always want caregivers to kind of get some stress relief, walking, meditation, family support, support groups, things like that. Always wanted to take some time off. I know personally when I went through the caregiving process with my folks, it got very overwhelmed at times, very wound up, stressed, you know, wasn't really my normal personality, you know, so have somebody kind of be your reality check with that. With my wife, for me, it was my wife, because I kind of helped her with that when her parents were going through it, to kind of keep you grounded, you know, because you can get overwhelmed with saying, I got to make every decision every time properly, you know, and there's really no properly. It's just really what works for you and your family at the time. Now, you might look back 20 years later and said, I could have done a better job. I think all of us do that. We're only human. But you can't constantly live in that world of I failed. Okay, you got to think about it differently. So, yeah.
Real quick, there's a question online. So I get that the originals of the various documents need to be notarized. Are the copies of the notarized copies legal, Or do they all need to have the original stamp?
Great question. I didn't address this. I should have. We hear from family members that they're questioned when they present copies of the original document. We've even had family members, because of that, have mom sign 10 original power of attorney forms, 10 original wills. Under the statutes, and any elder law attorney you consult will tell you this, the copy is as good as the original. Now, the workaround on that, when it's been questioned, what I advise families to do if they don't have an attorney working with them, is to bring the original to whoever's asking for that, show them the original, give them the copy to keep. If they need to scan that original into their system, they can do that. But under the statute, they cannot specifically request that they have the original given to them, okay? And it gets dicier, especially when you have out-of-state investment firms and stuff involved with certain aspects of the family. So if you can't do that workaround, the best thing you can do is have an attorney involved in your family planning. I know that adds to the cost. But once we told financial institutions, you'll be getting a letter from our attorney about what you're asking us to do, pretty quickly things get resolved, okay? Having that backstop does help. But no, in the state of Washington, if you're showing them a copy of the original, it's considered to be as legitimate as giving them the original. Okay, I hope that answers the question. Next, supportive counseling is useful. Like I said, support groups. Medicare now, I think, has allowances for counseling family caregivers. It's the first time they've done that. Apparently, they're doing that now. So again, talk to your doctor about that, bringing in family members for some guidance on counseling about caring for someone that might be ill, in which case it would probably be you. Next. Okay, lots of resources here at the end. Our office is there, 798-4600, and our website. And if you're thinking about someone in another part of the state or another part of the country, you can call us. We will tell you who is our equivalent support office in that other county in Washington, or in another state, who's the local support office. We're known as an area agency on aging. We have similar offices like us statewide and nationwide as well. Care facilities, we didn't talk about quality of care and concerns in them. Our long-term care ombudsman office handles those questions. So if you get to the point where you have a friend or family member going into care, skilled nursing, adult family, home assisted living, and there seems to be problems, disputes, a lack of quality care, you can call our office and they'll help you walk through that process of settling a dispute or filing a complaint if you need to. I mentioned WashingtonLawHelp.org. You can print out documents from there. I think they're designed where you can actually edit and complete them on the screen and print them out. Otherwise, you can print them out and fill them in. Social Security contact information on the 5 wishes document. Medicare, Medicare.gov. You can also call our office for help with Medicare counseling and decision making. The WACARES Act will be for folks doing long-term care planning who have been actively working since July of 2023. So that's not specific to the folks that if you're listening, you're already in a retirement situation. But if you've been working since July of 23, at least 500 hours a year, please call us. We can give you information about that long-term care benefit. The Bar Association has a senior citizen wills and trust panel. I believe they will set up powers of attorney, advanced directives, and a last will and testament for a reduced rate of a few $100s to get all that done. So if you want to have that attorney backstop, that's one way to do it at a reduced rate and get that all done. Or you can call the Dementia Legal Planning Project. They will help you with powers of attorney, living wills. They can't notarize for you, but they'll help you prepare them with a legal representative. You'd still have to do the last will and testament though. So there's different options there. You don't have to spend a lot of money to get these documents done. It can be helpful to involve an attorney depending upon the complexity of your situation. Not necessary, but please use the resources there to guide you. It's very helpful. Yes, question?
So to get started on a will and testament, I would go into the free legal guidance.
Yeah, right here, WashingtonLawHelp.org.
Yeah.
And it's like an online marketplace for information for everything from power of attorney forms, the last will and testaments. It has explanations provided by the Northwest Justice Project and the actual forms you can print out as well. Sometimes I see the last will and testament forms on there in a pretty easy to navigate way. Sometimes it's a little more difficult, but the power of attorney forms definitely are easy to print out, as is the last will.
So I'm gonna go into this and I'm gonna print off everything and fill it out, then I should take it to a lawyer.
If you want to have, yeah, you could certainly have an attorney double check everything to backstop you. If you chose not to do that, you would just need the documents notarized. That's it. And then you've got it. So it just kind of depends on how easy, how complex your situation. No mobile notaries are available. Well, they'll come out to your house and stamp. Some financial institutions will let you use their notary for certain things, especially if you're banking with them, they might. I've heard from others that they'll only notarize their own proprietary forms, so it kind of just depends on the situation there. But there's lots of mobile notaries around that will come out and notarize.
There's even virtual notaries that will do it over a Zoom session.
Oh my gosh,
Well,
really?
shocked by notarizing the
I didn't
forms
know that.
online
Wow,
over
wait,
Zoom.
that's pretty, yeah,
It's pretty wild.
So, any other questions, comments? Okay, thanks so much for attending, appreciate it, hope you learned something, grab some documents on the way out.
Yeah, and for those online, if you have any questions, you're welcome to unmute, or type it into the chat. Cheryl, I know you're gonna send me your address. Ruby, if you would like, any of the handouts that he mentioned in the beginning, I'm happy to scan them and send them to you. If you want one of everything, feel free to email me your address and I can put it all in an envelope and mail it to you. There will be a link to the recording on our website. Give us until probably the rest of the day to get that up, but you'll find it under events and classes on our website, and there will be a recording for each of our sessions. Our next session, Matt, I believe, is on identity theft.
Yes, scams, fraud, and identity theft, August 12th in Edgewood.
August 12th at our Edgewood station. So hope to see you all there. And thank you so much for joining us. I'm gonna stop the recording now.
It's a
I may use the restroom.
Absolutely.